So yes, today we're going to talk about once that order is final, there's no appeals, things have changed. And we're going to talk about what that means. So what do you do? What are your options? I have, kind of two basic options. Option one is the parties agree to change the custody order. So Carrie, if the parties just agree verbally, is that going to be enough? Do we need this in writing? Do we need a court order? How would you explain would be the best way to handle if the parties were to agree to modify a custody order?
Sure. So the best thing is always going to be to have an order from the court. Now, if two parties agree and they have a verbal agreement and they just trust each other implicitly, sure, they could go ahead and follow that, but chances are they don't trust each other implicitly in this situation. You're always going to want to reduce it to writing. And to do that, if we have an agreement, these parties can prepare what we would call a stipulation and order. Now, down here in the South, we do have a self-help center through the family court that they could simply get a form, fill out their new agreement, but it then would need to be submitted to the court, signed by the court, and filed with the court to become a court order. That's always going to be the best way to modify custody and make sure everybody knows their rights and responsibilities within that new custody order.
And same up here in the North, we have the same self-help center as well, which is a great tool for people to utilize.